A lot of gun owners woke up to one scary headline this week. The Supreme Court supposedly just ended carry permit delays nationwide. And if you believe that headline without checking the facts, you could make a decision today that gets you arrested tomorrow. Quick question before we go any further. Are you subscribed yet? Because this channel exists for one reason: to help you stay ahead of legal changes before they hit your life. If you care about your rights, your freedom, and not getting blindsided by bad information, hit that subscribe button right now. Now, let me give you the truth. The big viral claim is not the full story. As of right now, there is not some magic Supreme Court order that suddenly erased every carry permit delay in America overnight. What we do have is something almost as important. We have a clear warning from the Supreme Court, real pressure building in federal courts, a Justice Department investigation and lawsuit over long delays, and new cases that could shape what happens next. So if you carry, want to carry, or are waiting on a permit, this matters to you a lot more than most people realize. Here's what just happened, and here's why people are getting confused. First, you need to go back to the Bruen decision. That was the Supreme Court case that changed the carry map in America. Before Bruen, some states used a may issue system. That means the government could make you prove some special reason to carry, not just self-defense, something extra. The court said that was unconstitutional. In simple English, the court said regular law-abiding people do not have to beg the government for a special excuse before carrying for self-defense. But here's the part nobody talks about enough. The court did not say every permit system is illegal. In fact, the court said many shall-issue systems can still be okay. A shall-issue system is supposed to use clear rules: background check, training, fingerprints, forms, objective stuff, the kind of rules where an official is not supposed to play favorites. Now, this is where it gets interesting. The court also dropped a warning that should have every permit office in America paying attention. The justices said they were not ruling out future challenges if long wait times or crazy fees keep ordinary people from exercising the right to carry. Read that again in plain terms. The Supreme Court basically said this: a state cannot pretend to honor your rights while burying you in delays, costs, and endless paperwork. That is why you're seeing all this buzz right now. People heard that warning, then they saw new lawsuits over long delays, and then some channels turned that into the Supreme Court just ended permit delays nationwide. That is not the same thing. A warning is not a nationwide emergency order. A real legal opening is not the same as an instant legal victory. Let me break this down for you with a simple example. Imagine your state says, sure, you can apply for a carry permit. Sounds good, right? But then they make you wait 14 months for an interview, then another 6 months for review, then they lose your paperwork. Then they tell you to come back with more documents. At that point, your right exists on paper but not in real life. And that is exactly the kind of abuse Bruen seemed to warn about. Second, look at what has been happening in places with major backlogs. In California, the Justice Department announced an investigation into the Los Angeles County Sheriff's Department over claims that long permit delays were burdening Second Amendment rights. Later, the DOJ filed a lawsuit and said its review of more than 8,000 applications showed only 2 approvals, with some interviews set as far as 2 years out. Think about how wild that is. 2 years is not a short delay. That is the government putting your rights in a freezer. But wait, there's something even more important. This is not just a California story. In New York, there's also a federal appeal arguing that NYPD delays violate the Second Amendment and that the city has no real deadline for some later stages of the licensing process. So the pressure is growing from different angles, different states, different courts. Same basic issue. Rights delayed can become rights denied. If this is helping you make sense of the noise, imagine what my next video will do when I break down the exact words to use if an officer asks whether you're carrying. Subscribe now so you don't miss it, because that one could save you from making a huge mistake in a high-pressure moment. So what does this mean for you today? It means 3 things. First thing, do not assume your permit is automatically approved just because you applied. This sounds obvious, but people get sloppy here. They think, I submitted everything, I'm good. No, you're not good until your state says you are good, unless your state already allows permitless carry and you still meet every rule there. Carrying early because you saw a viral headline is how someone turns a rights issue into a criminal case. Second, do not assume every delay is legal just because the office says they are busy. That excuse might work for a week, maybe even a month in some places. But when the delay starts stretching into many months, especially past the deadlines in state law, now you may be looking at something very different. You may be looking at a constitutional problem. Third, start thinking like a record keeper, not just an applicant. Save every email, screenshot every portal message, write down every date. When did you apply? When did they cash your fee? When did they ask for fingerprints? When did they go silent? These details matter. If a case ever gets challenged, timelines become evidence. Here's a hypothetical example to explain this. Let's say you apply on June 1st. Your state law says the agency must act within 90 days. Day 90 comes and goes. Nothing. You call. No answer. You email. No answer. 4 months later, they tell you that your file was never complete, even though they never told you what was missing. That kind of game is exactly why people are paying close attention to permit delays after Bruen. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. And here's what most people get wrong. They think the biggest danger is denial. Sometimes it is not. Sometimes the bigger danger is delay. Why? Because a denial gives you something to fight. A delay keeps you stuck in limbo. No permit, no closure, no clean answer to appeal. Just waiting. And while you wait, life keeps happening. You still drive home late. You still run your business. You still protect your family. The need for self-defense does not pause because the permit office is backed up. Now, this is where it gets even crazier. Some states will act like the process itself proves the system is fair. They will say, see, we have objective rules. But an objective rule can still be abused if the state drags its feet forever. A right can be choked slowly just as easily as it can be denied fast. That is the real lesson here. And there is another trap. Out-of-state carry. A lot of people think if one state delays them too long, they can just use a permit from somewhere else and be fine. Maybe. Maybe not. Reciprocity rules are a mess. Some states honor outside permits. Some do not. Some honor resident permits, but not non-resident permits. Some have permitless carry, but still ban carry in huge lists of locations. Most people think, I have a permit, solves everything. The truth is, your rights can change the second you cross a state line. Hey, real talk for a second. A huge chunk of people watching right now are not subscribed. Don't be part of that group. Join the gun owners who want facts first, panic never, and updates before the headlines get twisted. Hit subscribe and be part of this community. Because this stuff changes fast. So where do we go from here? This is the part that shocked me. The fight over permit delays is probably not going away. It is getting bigger. You now have 3 lanes moving at the same time. Lane 1 is the Supreme Court's Bruen warning about long waits and high fees. Lane 2 is lower court litigation from real people saying, my permit office is stalling my rights. Lane 3 is federal pressure, including DOJ action in California, and growing attention on local systems that seem designed to slow walk applications. Most people think the next big gun case will be about bans, magazines, or age limits. But the truth is, the next huge issue may be something far more basic. How long can the government make a law-abiding person wait before a right becomes meaningless? That question hits home because it is not abstract. It affects the single mom closing her shop at night. It affects the truck driver stopping at a rest area after midnight. It affects the dad who lives in a rough neighborhood and just wants a lawful way to protect his family. So here's what you should do right now. Number 1, know your state's actual deadline, if it has one. Not what a clerk told you on the phone. Not what your buddy heard at the range. Read the rule. Number 2, separate state law from internet rumor. If somebody says, the Supreme Court fixed this for everyone, slow down. Ask what case. Ask what order. Ask what it actually says. Number 3, do not carry unlawfully because you are frustrated. I get it. Waiting is maddening. But becoming the test case by accident is not the move. Number 4, if your delay is extreme, talk to a real attorney in your state. Not a Facebook comment section. Not a random guy at the gun counter. A real lawyer. Number 5, understand that even if change is coming, change in court takes time. That is the hardest part. Rights cases can move slowly. Appeals take months, sometimes years. That is why records matter. That is why patience matters. And that is why accurate information matters so much. Here's the crazy part. The viral headline may be wrong, but the pressure behind it is real. We may not have a nationwide emergency ruling that ends delays tomorrow morning. But we do have legal momentum. We do have courts being asked to treat delay as denial. And we do have government agencies being forced to answer hard questions they used to ignore. Laws change fast, court fights move fast, and bad information moves even faster. Subscribe right now so you're not the last person to find out when the next ruling, appeal, or agency action drops. The next update could change what you need to do in your state, and I don't want you caught flat-footed. So here's the bottom line. No, the Supreme Court has not waved a wand and erased carry permit delays across America overnight. But yes, the legal ground is shifting and long delays are under more pressure now than they have been in years. If your state says you have a right to carry, it cannot hide that right behind endless waiting and hope nobody notices. If you want straight answers without the hype, make sure you subscribe, because that is what this channel is built for. I will keep tracking the cases, the rulings, and the real-world impact, so you do not have to sort through the mess alone. And one last thing, laws are different in every state, And facts matter in every case, so always check your local law and talk to a qualified attorney before you make decisions about carrying a firearm.